Welcome back to The Explainer. Now look, if you're tuning into this, you already know civil litigation isn't just a bunch of dramatic courtroom showdowns. It is a highly strategic game where cases are largely won, lost, or completely organized before a trial even begins. Today, we are opening up the pre-trial playbook to show you the procedural rules that govern this absolutely critical phase.
All right, here is our roadmap for today. We're looking at the trial shortcut, the government shield, the pre-game huddle, and drawing the battle lines. Let's get right into it.
Section 1. The trial shortcut.
Okay, so right off the bat, it's absolutely vital we clear up a common mix-up, distinguishing a merit-based summary judgment from a purely procedural default judgment. You see, a default judgment is basically a penalty. It happens because a defendant just completely failed to enter an appearance or file a defense on time. But a summary judgment? That has literally nothing to do with defaulting. It's for when a case is just so incredibly straightforward. Think of a clear-cut liquidated demand, and the defendant simply doesn't have a reasonable defense to stand on. Instead of wasting everyone's time with a full-blown hearing, the court just summarily decides the case right then and there.
To see this in action, let's look at how a real-world crisis tested these strict timing rules. The case is Danish brewing company East Africa Limited. They had acquired the rights to distribute Carlsberg beer in Kenya. But, well, we all remember COVID-19, entertainment joints shut down overnight. So all this imported beer gets stuck at the port, storage charges are just piling up, and get this, some of the beer literally expired. When the company inevitably couldn't pay its credit facilities, the lender sued both the principal debtor and the directors who had signed on as guarantors.
Now, timing is absolutely everything here. The plaintiff sued and immediately applied for a summary judgment. But they jumped the gun. You actually can't apply for a summary judgment before a defendant has entered an appearance. So naturally, the court strikes the application out. Next, the defendants file their statements of defense. But wait, the plaintiff immediately files a second application for summary judgment. The defendants push back, saying, hey, we've already filed our defenses, you're way too late for a summary judgment. But the judge looked closely at those filed defenses and realized the defendants fully admitted to signing the guarantees and defaulting on the debt.
And this leads to a brilliant ruling that really captures the core philosophy of the Kenyan Constitution. The judge pointed out that a defense is just one way a defendant shows they have an actual issue for trial. Since they already admitted the debt, there was zero real defense. The court explicitly stated that throwing out the summary judgment just because it was filed a little late would be, and I quote, to elevate a technicality to a fetish contrary to Article 159 of the Constitution. Basically, courts prioritize actual justice over rigid technicalities. And so, the plaintiff successfully won their summary judgment.
Moving on to Section 2, the government shield.
So when does this handy legal shortcut hit an absolute brick wall? Well, here is a somewhat surprising yet strictly enforced rule. The government can absolutely use a summary judgment against you as a plaintiff, but if you're suing the government, you can never ever use it against them. No way. So why exactly is that?
Well, it really all comes down to guarding public money. Think about it. You can't just attach a government building or a piece of public land to satisfy a debt. There is a deliberate, systemic mandate to protect public resources and assets. Plus, barring summary judgments against the state stops corrupt actors from colluding. It ensures state representatives can't just turn a blind eye and allow easy, undefended payouts to plaintiffs. If you want a judgment against the government, liability has to be formally, thoroughly found through the normal, rigorous judicial process.
All right, Section 3, the pre-game huddle.
So, what happens when summary judgment isn't an option and the case actually has to proceed? We enter case management under Order 11. The court essentially forces the parties into a room, which, is often a virtual one these days, to either organize for war or negotiate peace. Looking at the goals here, the main ideas are to promote settlement or alternative dispute resolution, expedite the disposal of the case, and drastically narrow down the issues. Ultimately, you're looking for one of two outcomes. The case is either fully settled right then and there, or it's officially certified as ready for trial. To get there, you've got a strict, unyielding sequence of events. It all kicks off the moment pleadings close. The plaintiff has a mandatory obligation to file a case management checklist within 14 days of that close. Then they have to serve this checklist on the other parties within another 14 days. After that, the parties fix a date for the case management conference. And hey, if anyone wants to make specific requests, like say asking for interrogatories, amending pleadings, or referring the case to ADR, they have got to file a case management request at least 7 days before the conference.
Now, the court categorizes the urgency and complexity of your dispute, and that dictates just how fast this whole huddle has to happen. If you're on the fast track, your conference has to be held within 60 days of serving the checklist. For multi-track cases, you get up to 90 days. Keep in mind, small claims are entirely exempted from Order 11 because they run on a totally different, much faster procedural track anyway.
Historically, though, this whole pretrial process was kind of an inside joke. Senior advocates would frequently just not show up. Instead, they'd send a junior pupil or a clerk with a little note saying, "We have complied with Order 11, just to hold brief." And when the judge would inevitably ask a basic question like, "Hey, do you intend to call a witness?" the junior lawyer would give the classic response, "I'm sorry, my lord, I was simply holding brief and I have limited instructions." Yeah, the courts got completely fed up with this waste of time.
So, because of those infuriating past excuses, the strict rule today is clear-cut. Whoever steps into that virtual or physical courtroom for the case management conference absolutely must be empowered. You have to be the advocate on record or a designated advocate with full instructions to make binding decisions right there on the spot. If the judge asks about mediation, you can't just hide behind limited instructions anymore. You literally must be able to bind your client to a settlement, ADR, or procedural directions. No more passing the buck.
And to maintain absolute control over this phase, judges are armed with a pretty powerful weapon, unless orders. This is a super strict judicial direction. The court might give you a limited time window to file an amended pleading or a bundle of documents, but with a lethal catch, unless you comply by the exact deadline, your suit stands automatically dismissed or struck out. It basically means comply right now or your case dies today. It's a real game changer.
And finally, Section 4. Drawing the battle lines.
If the pregame huddle fails to settle things, we have to officially define the battlefield. In civil litigation, an issue has a very precise definition. It arises when there is a material proposition of fact or law that one party affirms and the other party explicitly denies. Let's say the plaintiff claims a contract exists, and the defendant says, "Nope, it doesn't." That material disagreement right there, that becomes a distinct issue for the trial. If both parties agree the contract exists, well then its existence is absolutely not an issue.
Ideally, figuring out what issues the court will actually rule on is supposed to be a collaborative effort. One party drafts the proposed issues and shares them. The other side reviews, makes edits, and eventually they both sign an agreed statement of issues to file with the court. But we all know how litigation goes. If the parties just cannot agree and keep bickering, they each file their own separate lists. At that point, the judge steps in, reviews the pleadings, and forcibly settles the actual issues, locking in the final list that will guide the hearing.
So I want to leave you with this final, absolutely vital thought. A trial is solely about answering those specific settled issues. Every single piece of evidence, every witness you call is specifically meant to persuade the judge to determine those exact issues in your favor. If you step into a courtroom without a crystal clear understanding of the agreed or settled issues, what on earth are you leading evidence to prove? This entire pretrial playbook exists because litigating a case without knowing the exact issues is literally like fighting a war completely blind. Definitely something to keep in mind as you prep your next case.